huge fan of that rule, but you don't.
Well, no, there's the decision goes through the analysis of the state's contact to the person and the interest the state has in protecting the rights of this person. It was a fairly lengthy, sort of thoughtful decision.
Whether you agree with it. California Supreme Court decision?
I believe it was, wasn't it?
Do you all know the name of it?
I don't know what level.
But it was in the news like a couple of weeks ago.
Okay, I'll look for that.
It was a long-arm statute issue.
So, correct me if I'm wrong, because I don't really follow this that closely, but weren't ISPs denied common carrier status? There was some doubt about that.
They are not common carriers.
They're not common
Period.
So would it not be the responsibility of the administrator to monitor their network? Because if their network was then used for illegal purposes, they would be liable.
I think you're confusing a lot of concepts here.
This is worth trying to straighten out, although sadly I can't straighten it out for you.
We're not
I don't really know telecom law. But there seems to be this perception that there are common carriers who have some kind of immunities that others don't. And it really has more to do with your regulatory status and what obligations you have.
And there's Section 230 of the Communications Decency Act, which has applied to lots of ISP non-common carriers, which gives them a free pass from all sorts of different liability.
Except for criminal and IP-based liability.
Okay.
But that applies to everyone, whether telecom or ISP.
And so that has nothing to do with whether or not you're a common carrier. It's a pretty broad immunity that applies to lots of different providers.
So would it apply in this case to their network?
Yeah, we sued him. I mean, he was brought. The charges were brought on him as an individual. So the question is, does he get to take advantage of the enterprise immunity? And oh, wait, hang on, I'm confusing everything. This is about their act. What we were talking about is the immunity for what other third parties do on your network. This is their act.
The
This is
Communications
his
Decency
act.
Act Section 230 basically says if other people are using your network for stuff, you're not liable for it, except that carve-out is limited. It doesn't count intellectual property violations. It doesn't count criminal violations. And so I've yet to see a case where it's even been attempted, much less successfully, to hold someone criminally liable for something that happened on their network that they they were not aware of. And then there's particular safe harbors regarding IP. So,
Yeah.
How are they going to be aware if they didn't sniff?
The reason I ask this is that every use agreement I've ever signed with an ISP in like the last 5 years that basically says you accept monitoring. So obviously they're covering themselves.
yes.
So it seems like there's a legal pressure there for them to monitor.
No, it's more of a pressure to avoid liability in case they want to monitor or they screw up and accidentally monitor for an improper reason or whatever. But yeah, I mean,
It just covers them. It's
basically, yeah, it is ass covering.
if you can get your customers to agree to it and there's no cost in the market, then why not do it? It's just another layer of cover.
And sadly, there's clearly no cost in the market.
We had a question in the back.
Going back one comment, take your favorite two-party consent state. Has anyone tried using the argument that if you're sending an email, you're establishing a connection between your computer and your ISP's mail server, so those would be the two parties that consent?
Yeah, and we hear these arguments all the time. We hear the arguments. Well, again, in 2001 with the Patriot Act, there was this new thing added called hacker trespasser, and I don't want to go into all the details, but one of the things that was debated is who are parties? Are all the little machines in between? And there actually is some pretty good case law. Some of it's surprisingly old, like these weird teletype systems in the 70s. And courts have said, yeah, I mean, it wasn't the most rigorous analysis, but they're like, party over here, the guy on the teletype machine. Party over here, the guy who set up this server a couple of weeks ago. No problem. All party consent. So there's precedent for it, but it's like I said, not intellectually satisfying.
I mean, there are strong arguments that they're simply not a party.
Yeah.
And if they were a party, it would make the federal regime in terms of the provider make no sense. I mean, the provider exception applies to telegraph operators and all these other people who are the kind of intermediary you're thinking of, but they clearly are not parties, or else they wouldn't need that exception because they'd be consenting to it themselves.
And there's a difference between email servers where you're issuing SMTP commands and routers where it's just passing. I mean, there's a lot of different ways you could spin that out. So.
Question in the middle here.
Thinking from the system admin angle, assuming the system admin works for a company and they accept he wants to protect himself. Assuming in this case, system admin creates the program, he sets everything up, but he doesn't press the enter key. And he has someone else press the enter key.
Oh, no, that's...
There's probably a conspiracy argument there.
There's also... Actually, I believe the interception may actually be Maybe not. I mean, there's a catch-all section in the criminal code that says you have someone else do it on your behalf.
Yeah, it includes the interception or procuring someone else to intercept.
So it's both in the statute itself and it's a catch-all. Yeah, that's not going to save you.
So corollary to that, in the story, right, the CISO said you're looking for someone else. He did not seem like a good candidate. Let's assume that he was not a good candidate because he did not agree with this, and they did not give him a job. So could he soon say he wanted me to do something criminal, and my refusal to do something criminal is why I didn't get the job?
Yeah, I don't know about that.
No, I mean,
I don't know what your cause of action is. You didn't hire me. I don't know.
So this accident's really happened.
no, I mean, if he did it
You
on
can
their
quit.
orders,
You can quit and stop making money. That's a attractive one, but yeah.
I mean, if he did it on their orders and then he got sued for it and sued for damages, he could seek to sue them to make them pay the damages.
Well, you might even have a. Well, maybe.
Well, yeah, no.
Question here? No question? You had a question.
Well, I guess this is kind of a CY. You know, I mean, everything's going to him because he's the only guy that knows what's going on, correct?
Who?
And
To Brian, yeah.
So is it fair to say that they asked him to do something that was illegal?
No, because they were really vague about what they were saying. They were just saying.
They did not say sniff traffic, monitor this.
So
We could have set up the facts differently. We could have made this big, like Abu Ghraib, right? We could have made it. They just push down the responsibility, but we didn't. That's how we said
turned
it.
it on him
Because he did it?
So really, the only way that he could have got out of it was by not doing anything. Is that
Yeah, and we understand where you're going with this. That's not a really attractive option, right?
right?
It doesn't necessarily work. You both may be committing a crime at that point.
Right, but then the employee is working under the direction of the employer. Therefore, he personally has.
Well, it might be a defense, but I mean, do you guys know about these cases?
This is one thing that if we had made that adjustment to the case, a minor adjustment, it would have changed the overall case considerably.
And they might have indicted the company, and they might have indicted the CISO and the system.
Right.
Richard, do you guys have something to add on that?
Even if you're doing it on behalf of the company and the company doesn't direct you to do it, but you are doing it in following the company's policy, the company can be in fact criminally liable. Not the directors themselves personally liable, but there's responsible corporate criminal liability.
Right.
So they can be found.
If you're acting as their agent, right? Yeah, but we have this layer of immunity. Yeah, again, this is stuff that I don't. This is not my area of expertise.
But I mean, I wouldn't let the sympathy go too far in terms of the, oh, my boss told me to do it. I mean, if your boss told you to murder someone, would that mean you should get off the, I mean...
I think this is a little grayer, though. I mean, this is...
a little, I guess. But, I mean, but the basic principle, just because your boss told you to do it, does not get you off the hook.
Well, no, but the sympathy, I think, goes to what do you actually do? What do you actually do? And I guess what you do now is you say, I just got back from BlackHat, and 2 lawyers said that I'm committing a felony, and I'd rather not do that today. I guess.
Unless they have consent.
You know what? The reason I love this topic is because everyone does this. Everyone's doing content filtering. Sometimes it's for rights and property, sometimes maybe not, but everyone's doing it. And so the question is, do you have the protection under this law? The government hasn't started indicting lots of people for this, but who knows? Maybe they'll get bored and turn to you guys now.
Just got another question on him. Is it his responsibility to know that everybody has...
That's good. Well, again, this was the same question we had earlier, right? I think that's not going to be a sufficient defense. It's not going to be enough to say...
I guess I'm just looking at a CYA kind of thing, and, you know, obviously, you know, everything's getting piled on him, the buck stops there. You know, is he the guy that has to know that everybody says it's fine, you know?
We might be blurring from the world of what does the law say to what's your jury appeal. If you can get up there and say, they told me that everyone consented, and they said that everyone was signing a piece of paper, and this guy didn't sign a piece of paper, how was I supposed to know that? You may not get indicted or charged in that case.
Yeah, cut off debate. It's 8 o'clock.
Okay.
Exactly.
You got a better case. So for those of you who have been told by your employer that all of your employees and contractors are signing documents, I wouldn't worry. I wouldn't lose any sleep. Right? You're not about to get charged or sued for any of this stuff. But if they say it and you don't believe them for some reason, or you have a reason not to believe them, I'd start asking questions.
Like you weren't asked to sign what they say they took.
Okay, I'm going to have to stop the questions because it's 8 o'clock and they really want us out of here by 8. I wanted to thank everybody for coming. Please fill out your comment cards. If you really enjoyed the show, tell the BlackHat folks you enjoyed it. Thank you for coming.